The FBI did not interview the sources of the Steele dossier that falsely accused President Donald Trump of being a Russian agent until January of 2017, after the FISA warrant had already been renewed. Hello, this is Robert Romano, Vice President of Public Policy with Americans for Limited Government, dailytorch.com. Hit that subscribe button. Today we're going to be talking about the long-awaited Inspector General of the Justice Department report from Michael Horowitz. This is a devastating 476-page report that details abuses of the Foreign Intelligence Surveillance Act by the Justice Department and intelligence agencies against the Trump campaign in 2016. When the Obama administration, in an unprecedented move, obtained top secret surveillance on the presidential campaign, the Trump campaign, the opposition party in an election year, and it may have been on the flimsiest of grounds based upon concocted information with witnesses who ultimately contradicted one another, and none of the president's chief accusers ever stood by the allegations, only saying that they needed to be further corroborated. One of the other witnesses said it was hearsay and that this was allowable. Non-witness statements were allowable in the FISA court, the most top secret surveillance court in the country, that is supposed to safeguard the Fourth Amendment against unreasonable searches, but it allowed non-witness statements to be admitted as a basis for engaging in surveillance of several U.S. persons, including Carter Page, who was a foreign policy advisor of the Trump campaign in 2016, his contacts, and so presumably the Obama administration and the Justice Department had unprecedented access to presidential campaign emails, telephone calls, text messages, and other documents. And so this is an outrageous abuse of power by the Obama administration. And finally, we're getting some information about the abuses by the Justice Department. Here's the Office of Inspector General report. And I think this is devastating. Because the FBI did not begin the process of validating information by interviewing former British spy Christopher Steele's sources. He was hired by Fusion GPS, who was hired by the DNC and the Hillary Clinton campaign to do opposition research into President Trump on the Russia question. And Steele came back with all of these outlandish allegations that President Trump, then candidate Trump, was a bought and paid for Russian agent, that Trump and his campaign, with full knowledge and support, had helped Russia with the DNC hacks and putting the emails onto WikiLeaks, that there was a conspiracy, that Paul Manafort managed this, and that Carter Page was supposedly this intermediary. The only information the Justice Department ultimately had on Carter Page was that he happened to travel to Moscow in 2016 to deliver a speech at the New Economic School. It was a commencement address. This was publicly available information at the time of the FISA warrants. It came months before the FISA warrants were ultimately approved in October of 2016. But they didn't begin interviewing the sources, Steele's sources, until January of 2017, which was months after the initial application had been sought, and after it had already been renewed once. And one presumes, after BuzzFeed published the dossier that the Justice Department had depended upon so mightily. The Justice Department took it all on faith, though. Steele said he had all these connections to Kremlin insiders. But then when the FBI got around to interviewing Steele's primary subsource, he contradicted all that and said that it was all hearsay. So maybe that's all it took in the Obama administration to get top secret surveillance of the Trump presidential campaign, the opposition party in an election year. Well-placed gossip from well-credentialed officials. It doesn't even need to be true or verifiable. In fact, per Horowitz, no efforts were made to contact Steele's sources prior to obtaining the spy warrants in October. And then really they didn't go at it until after the election and after surveillance had already been renewed once in January of 2017. Here, Horowitz doesn't tell us what date in January that the FBI finally got in contact with the primary so-called source there. But according to the Inspector General report, the quote, the primary subsource made statements during his January 2017 FBI interview that were inconsistent with multiple sections of the Steele reports, including some of which were relied upon in the FISA applications. Among other things regarding the allegations attributed to Person 1, the primary subsource's account of these communications, if true, were not consistent with and in fact contradicted the allegations of a well-developed conspiracy that Christopher Steele had alleged. Per Horowitz, quote, the FBI's receipt of election reporting on September 19, 2016, however, played a central and essential role in the FBI's and the department's decision to seek a FISA order. So without Steele, they had nothing, and Steele, without his sources, he didn't have anything either. And if they had tried to verify the information prior to getting spying on a presidential campaign, this whole thing might have been nipped in the bud. They probably would have never gotten the surveillance in the first place. The only official who appeared to ask any questions was then National Security Division Deputy Assistant Attorney General Stuart Evans, who held up the FISA application because he said it was biased because the DNC and the Clinton campaign had paid for it. And so Evans fought for and had included in the FISA application warrant on Carter Page a footnote that detailed the conflict of interest, or the fact that the people who were making the allegations were actually the DNC and the Hillary Clinton campaign. It was kind of obfuscated because in the FISA warrant, they don't actually use real names. They minimize the names of U.S. persons and U.S. entities. And so, but that's who they were referring to in this footnotes. And Evans told the Inspector General that if the subsource's contradictions with the other witness statement had been brought to the National Security Division's attention, it would have been cause to cancel any more renewals for this FISA application against the Trump campaign, and by then the Trump transition and what was soon going to be the Trump administration in January of 2017. Per Horowitz, quote, according to evidence, had the Office of Intelligence been made aware of the information, such discussions might have included the possibility of foregoing the renewal request altogether, at least until the FBI reconciled the differences between Steele's account and the primary subsource's account to the satisfaction of the Office of Intelligence, but instead they covered it up, quote, however, we found no evidence that the Crossfire Hurricane team ever considered whether any of the inconsistencies warranted reconsideration of the FBI's assessment of the reliability of the Steele reports or notice to the Office of Intelligence before the subsequent renewal applications were filed. Instead, the second and third renewal applications provided no substantive information concerning the primary subsource's interview. And in fact, they made it sound like the subsource had corroborated Steele when in fact the subsource had contradicted Steele's accounts on almost every point. Quote, offering only a brief conclusory statement that the FBI met with the primary subsource, quote, in an effort to further corroborate Steele reporting, and found that the subsource was, quote, truthful and cooperative. We believe that including this statement without also informing the Office of Intelligence and the court that the primary subsource's account of events contradicted key assertions in Steele's reporting left a misimpression that the primary subsource had corroborated the Steele reporting, but Steele's sources had not corroborated that reporting. They had contradicted it. Going back to Steele's allegations, he had alleged that there was, quote, a well-developed conspiracy of cooperation between Trump and senior members of his campaign. Quote, this was managed by Trump's side by Republican candidate's campaign manager, Paul Manafort, who was using foreign policy advisor Carter Page and others as intermediaries. The two had a mutual interest in defeating Clinton, whom Putin both hated and feared. Inter alia sourcii acknowledged that the Russian regime had been behind the recent leak of embarrassment email messages emanating from the Democratic National Committee to the WikiLeaks platform. The reason for using WikiLeaks was plausible deniability, and the operation had been conducted with the full knowledge and support of Trump and senior members of his campaign. But when the FBI interviewed the subsource of its statement, per Horowitz report, the primary subsource, quote, did not recall any discussion or mention of WikiLeaks. On President Trump's alleged activities at the Ritz-Carlton Hotel, according to the Horowitz report, quote, the primary subsource told the FBI that Report 80 stated Trump's alleged sexual activities at the Ritz-Carlton Hotel had been confirmed by a senior Western staff member of the hotel. The primary subsource explained that he or she reported to Steele that alleged unorthodox sexual activity at the Ritz-Carlton Hotel was, quote, rumor and speculation, and that he or she had not been able to confirm the story on details that foreign policy advisor Carter Page had been offered a stake in Rosneft worth billions. Those were apparently made up. Quote, a meeting allegedly held between Carter Page and Igor Sechin, the president of Rosneft, a Russian energy conglomerate, stated that, according to a close associate of Sechin, Sechin offered Page Trump's associates the brokerage of up to a 19% privatized stake in Rosneft in return for lifting the sanctions against the company. The primary subsource told the FBI that one of his or her subsources furnished the information for that part of Report 134 through a text message, but said that the subsource never stated that Sechin had offered a brokerage interest to Page. We reviewed the texts and did not find any discussion of a bribe, whether as an interest in Rosneft itself or a, quote, brokerage. Steele had also alleged that former Trump attorney Michael Cohen had traveled to Prague in the summer of 2016 to mop up the supposed fallout of the WikiLeaks email disclosures and Trump's supposed role in that. Here, too, the FBI, however, ultimately debunked that allegation. Per Horowitz, quote, the FBI determined that some of the allegations in the Steele reporting, including that Trump attorney Michael Cohen had traveled to Prague in late summer of 2016 to meet with Kremlin representatives and that anti-Clinton hackers had been paid for by the Trump team and the Kremlin, were not true. The FBI had debunked these allegations. When did they do that? Who knows? But this information was never turned over to the FISA court, all of this exculpatory information. And that should have been it. That should have been the end of the investigation, but it did not, thanks to the recusal of former Attorney General Jeff Sessions. It went on with the FISA warrant being renewed and the investigation of Trump administration deepening with the appointment of special counsel Robert Mueller. In March of 2017, when the FBI returned to question the primary subsource again, it again undercut the veracity of Steele's reporting. Quote, the primary subsource felt that the tenor of Steele's reports was far more, quote, conclusive than was justified. The primary subsource also stated that he or she never expected Steele to put the primary subsource's statements and reports or present them as facts. According to an agent, the primary subsource said he or she made it clear to Steele that he or she had no proof to support the statements of his or her subsources, and it was, quote, just all talk. It gets better. In March, the primary subsource admitted that it was all hearsay. Quote, the primary subsource explained that his or her information came from, quote, word of mouth and hearsay, quote, conversation that he had friends with over beers, and that some of the information, such as allegations about Trump's sexual activities, were just made in, quote, jest. The primary subsource also told the agent that he or she believed that the other sources exaggerated their access to the information and the relevance of that information to his or her requests. The primary subsource told WFO agent that he or she takes what the subsources tell him with a grain of salt. Now, we already knew that Steele had never been to Russia and that he had relied on a network of subsources per Horowitz. Now we know that the primary subsource used subsources of his own, and not even they had access to the persons being reported on. Quote, the primary subsource stated that the agent, in contrast to the impression left from the election reports, his or her subsources did not have direct access to the persons they were reporting on. Instead, the primary subsource told the agent that their information was from someone, quote, who may have had access. Steele, now, his sources, and if you read the Steele dossier, he makes it sound like it's direct reporting, real quotes. He cites a former top Russian intelligence officer, Source A. Source B was a senior Russian foreign ministry figure. Source C was a senior Russian financial official. He had close associates of Trump, people who supposedly worked at the hotel. Source G was a senior Kremlin official. Now we know, based upon the Steele's primary subsource reported in the Horowitz report, that these were not sources at all. It was all hearsay, sources with subsources who had subsources. Johnny told Susan, who told Sally. And that's how we get a FISA warrant against the Trump campaign and destroy the Constitution and throw out the Fourth Amendment. Now we know, based on Steele's primary subsource, that none of it was true. And even Steele himself, when he was questioned by the FBI, called his source a, quote, boaster, quote, an egoist and, quote, may engage in some embellishment. And yet all this information was kept out of the FISA application and its 3 renewals. So by January 2017, this investigation should have been thrown out. But by June, they're still getting new FISA warrant reapplications and renewals, even under Bob Mueller. In court testimony later, Steele would say that all material, quote, contains this risk of being disinformation, stating that the allegations needed to be, quote, further corroborated and verified. James Comey, he testified in January 2017 when they were renewing the FISA application that the information they were using in the FISA renewals was, quote, salacious and unverified. Eventually, Special Counsel Robert Mueller, he debunked the entire conspiracy theory that Trump and his campaign were Russian agents. This is from the Mueller report on 2016 Russian interference. You know what he didn't find? Trump interference in the elections based upon being Russian agents. Quote, the investigation did not establish that members of the Trump campaign conspired or coordinated with the Russian government in its election interference activities. And quote, the evidence does not establish that the president was involved in an underlying crime related to Russian election interference. And this included all members of the campaign. Per Mueller, quote, the evidence did not find evidence likely to prove beyond a reasonable doubt that campaign officials such as Paul Manafort, George Papadopoulos, and Carter Page acted as agents of the Russian government or at its direction, control, or request during the relevant time period. And then as for Mike Cohen, per Mueller, quote, Cohen had never traveled to Prague. And that also, again, discredits key allegations of the Steele dossier. If Michael Cohen's never in Prague, then he can't be there talking to Russian agents about mopping up the fallout of the WikiLeaks disclosures, because he never spoke to Russian agents, and certainly not in Prague. And even after the application was resubmitted over and over again, and even after the exculpatory information was widely known to the department's top leadership, the department conspired to conceal that information from the FISA court. Crossfire Hurricane team, they were answering directly to Andrew McCabe. Andrew McCabe knew that this information was bunk, but per Horowitz, quote, the second and third renewal applications provided no substantive information concerning the primary subsource's interview when the key witness on behalf of the government was contradicting the facts that were stated to the court in a court of law to a federal judge. They kept that away from the federal judge. Mueller managed to keep it out of his final report. He doesn't mention the fact that key witnesses contradicted key claims in the Steele dossier. He doesn't mention that the Steele dossier is widely used. It's in the FISA warrants. He doesn't cover any of that. Thank goodness for Horowitz. Thank goodness for the Horowitz report. Now we know that this was the basis for the spying on Trump and his campaign in 2016. And here's the real kicker, though. Even with all of these discrepancies and contradictions, if known at the time, might have been cause to stop the spying dead in its tracks and meant that there was no FISA applications, Horowitz remarkably finds that the FISA applications were apparently allowable under the law, meaning the problem is FISA itself and the standards of evidence, the weak standards of evidence used to obtain top secret surveillance on American citizens, or so we have been led to believe these last few years. Was this a legal application to the FISA court? I think that's for Attorney General Barr to decide. I think that's for U.S. Attorney John Durham to decide. Horowitz does not reach a conclusion about the legality of the FISA applications. Again, the Attorney General, by regulation, oversees FISA process. So does the Chief Justice of the Supreme Court, John Roberts. I think he has a little bit of explaining to do. Maybe somebody should call him to testify. Maybe Lindsey Graham should pay a visit to the courthouse and ask him what documents they have over there and start subpoenaing stuff, because I think this is a massive scandal of the judicial branch, of the intelligence agencies, of the Justice Department. This whole thing stinks. And the problem is these weak standards of evidence used before the FISA court. Hearsay is allowed. Political gossip is allowed. Non-witness statements are allowed to be submitted as if they were factual. They're not even sworn affidavits. Now, they might as well use rubber stamps over there. Probable cause under these circumstances is whatever the agents and their supervisors believe it is, and then the FISA court just says, yeah, okay, let's spy on Trump. Here, the report from Horowitz, it's a case study in arbitrary decision-making and the moving of goalposts. Whenever there were facts that contradicted Steele's claims, they just hand waved it away and said, no, that's not important. We're going to continue to renew these applications and spy on the president of the United States. But even before the FISA warrants were granted, Horowitz does find that based on the information they had at the time, that was supposedly, quote, sufficient to predicate the investigation. Here, Horowitz cited the, quote, the low threshold for predication in the AG guidelines by Attorney General, which are in place, and maybe William Barr, he wants to revise those to make it a little tougher to initiate investigations against presidential campaigns. But in any event, these agents, they have pretty wide discretion and broad latitude with which to launch investigations. According to Horowitz, quote, this information provided the FBI with an articulable factual basis that, if true, reasonably indicated activity constituting either a federal crime or a threat to national security, or both, may have occurred or may be occurring. For similar reasons, we concluded that the quantum of information articulated by the FBI to open individual investigations on Papadopoulos, Page, Flynn, and Manafort in August of 2016 was sufficient to satisfy the low threshold established by the department and the FBI. But this all comes with a grain of salt. We now have a statement from Attorney General William Barr on the Horowitz report. He says, quote, the Inspector General's report now makes clear that the FBI launched an intrusive investigation of a U.S. presidential campaign on the thinnest of suspicions that, in my view, were insufficient to justify the steps taken. It is also clear that, from its inception, the evidence produced by the investigation was consistently exculpatory. Nevertheless, the investigation and surveillance were pushed forward for the duration of the campaign and deep into President Trump's administration. In the rush to obtain and maintain FISA surveillance on Trump campaign associates, FBI officials misled the FISA court, omitted critical exculpatory facts from their filings, and suppressed or ignored information negating the reliability of their primary source. The Inspector General found the explanations given for these actions to be unsatisfactory. While most of the misconduct identified by the Inspector General was committed in 2016 and 2017 by a small group of now former FBI officials, the malfeasance and misfeasance detailed in the Inspector General's report reflects a clear abuse of the FISA process. This is unbelievable. U.S. Attorney John Durham, he has also issued a rare statement, and he disagrees with Horowitz on the predication. Here, quote, I have the utmost respect for the mission of the Office Inspector General and the comprehensive work that went into the report prepared by Mr. Horowitz and his staff. However, our investigation is not limited to developing information from within the component parts of the Justice Department. Our investigation has included developing information from other persons and entities, both in the U.S. and outside the U.S., based on the evidence collected to date. And while our investigation is ongoing, last month we advised the Inspector General that we do not agree with some of the report's conclusions as to predication and how the FBI case was opened. This is devastating to the Justice Department. This is a dark day for the Justice Department and our federal government, our intelligence agencies. This is a mark of shame, but it comes with a ray of hope, I think. Attorney General Barr and U.S. Attorney John Durham, they're getting to the bottom of this, and we need to reform FISA. If this was allowable under the Foreign Intelligence Surveillance Act, then we need to reform it or repeal it, because we can't have the Justice Department and the intelligence agencies spying on opposition parties or the incumbents or the administration or spying on the president. We can't have that happening in secret without the executive branch having full self-awareness of all the investigations that are being undertaken. We need serious reforms here. The president's going to need to issue executive orders probably to reorganize the way we gather intelligence, the way these investigations are started. The Attorney General probably needs to issue new regulations. Attorney General Barr did note that the FBI director is going to be issuing new rules related to this, quote, FISA is an essential tool for the protection and safety of the American people. The Department of Justice and the FBI are committed to taking whatever steps are necessary to rectify the abuses that occurred and to ensure the integrity of the FISA process going forward. No one is more dismayed about the handling of these FISA applications than Director Wray. I have full confidence in Director Wray and his team at the FBI, as well as the thousands of dedicated line agents who work tirelessly to protect our country. I thank the director for the comprehensive comprehensive set of proposed reforms he is announcing today, and I look forward to working with him to implement these and any other appropriate measures. With respect to the DOJ personnel discussed in the report, the department will follow all appropriate processes and procedures, including as to any potential disciplinary action. So you have disciplinary actions, personnel actions, criminal investigations that are all occurring because of the Steele dossier was submitted to the FISA court, and it can contain false information. And we know that now from the U.S. Inspector General, Office of Inspector General at the U.S. Justice Department, Michael Horowitz. And the aspects of FBI's Crossfire Hurricane investigation. Now we finally have answers as to how and why well, maybe not so much to why. I think Durham's going to tell us why, but certainly to how the Justice Department came to spy on a presidential campaign. This is the gravest abuses of the FISA process in its history. Frank Church, the Church Committee in the 1970s, it basically led to the adoption of FISA to prevent political spying. They were spying on Congress people, journalists, people who were anti-war protesters in the 1960s and the 1970s. And it was a CIA operation on domestic soil. And so FISA was supposed to prevent these abuses from ever occurring. Instead, it appears that FISA was used to authorize political spying on the opposition party in an election year. The spying was carried over into the Trump administration after Trump won the election. And then they must have been spying on the White House. They must have been spying on the president. And Carter Page, his contacts, I guess if any of them worked at the White House, then the FBI and the Justice Department had a plumb line to information that the executive branch was considering. You had basically more than one executive branch. This should have never happened. They had exculpatory information, contradictory witness statements in January of 2017, presumably before Trump was even sworn in. Instead, they carried the investigation on over into the Trump administration. James Comey lied to President Trump about the extent of the investigation. He never made President Trump aware of the fact that there was all this contradictory witness statements. And he never, what did the Attorney General know? Jeff Sessions, was he ever advised that there was all of this exculpatory information? How and why was he forced to recuse himself? Was he given the full information? According to Horowitz, senior members of the Justice Department were not made aware of the contradictory witness statements. That was kept close to vest by the Crossfire Hurricane team and the FBI, although Andrew McCabe certainly should have known about it because Strzok and Page, who were running this operation, were answering directly to McCabe. And I'll leave you with the close here. There's going to be hell to pay for this. AG Barr, he needs to fix this. He needs to fix this now. And here's the close, meaning there are more revelations to be had in terms of the origins of the Justice Department and intelligence agencies' false allegations that Trump and his campaign were Russian agents. We're going to hear from John Durham. I'm sure he's going to have some indictments that are going to be coming out of this. There better be. The troubling part here is that FISA, designed to prevent this sort of political spying from occurring, appears to have allowed it. The court approved the warrant. So the court, it wasn't warrantless surveillance. It was a warranted surveillance. They had a warrant. And it got renewed 3 times. The troubling part here is that we're supposed to stop this, but now with the reauthorization of FISA being kicked off until March, we need to ask whether FISA can be fixed to prevent this from ever happening again, or if it should just be repealed. This is a day of shame for the Justice Department, but it provides a ray of hope that liberty might be restored, but only if justice is delivered. We are looking to you, Mr. Attorney General. Show America how it's done. That's the commentary. This is Robert Romano, Vice President of Public Policy with Americans for Limited Government, dailytorch.com. Hit that subscribe button, ring the bell for notifications, and have a good day.